behalf of Mr. Talisman, and I believe he's in the courtroom.
He is. People of the State of Michigan versus David Walter Talisman. Appearing on behalf of the people, Assistant Prosecuting Attorney Alexander Pani. Three case numbers 7158, 78, and 7184, all 24 cases. And there was a motion filed by the prosecution regarding subpoenas that were signed by the court. Mr. Pani, you may proceed.
Thank you, Your Honor. This is the People's Emergency Motion to quash subpoenas ducis tecum. As a factual background, on Tuesday, April 29 of this year, the people received via email two subpoenas ducis tecum for signed by counsel for the defendant as well as the court for medical records for a party to this case, Shanna LaViolette. Those subpoenas were issued to Dr. Craig McManaman and Dr. Hanselman, requesting medical records for Shanna LaViolette for a period of 5 months in 2024. The request was for medical records from January 1 of 2024 through the end of May 2024. I would note for the court that the date of offense for these three cases is July of 2024. So these are medical records prior to the institution of this case. Your Honor, in order to, the people are asking.
The judge listened carefully as both sides battled over privacy, credibility, and the defendant's right to build a defense. But when attorney Karen refused to fully explain what she was searching for, the courtroom tension instantly escalated.
For a quash of these subpoenas pursuant to MCR 2.305, parents A, parents 4, parents small a, that grants the court authority to quash or modify a subpoena if it is unreasonable or oppressive. The people's argument is that medical records for an individual in this case are totally irrelevant to the charges that the defendant faces here, those being multiple counts of home invasion, improper access of a computer system, and aggravated stalking. The people have cited the authority for motions to quash as well as the court's authority to quash those subpoenas for immaterial information. Your Honor, the people received defendant's response to this motion at 8 p.m. Last Friday, so we've had an opportunity to make a cursory review of it this morning. It appears as though the defendant's argument is that because the aggravated stalking count requires the people to prove beyond a reasonable doubt that there was a valid personal protection in order at the time of the alleged allegation of aggravated stalking, that the defendant is therefore somehow allowed to access the protected health information of the petitioner in that personal protection order. Your Honor, the people can't see any relevance whatsoever to her medical records that may have been submitted as part of her petition for a personal protection order. Now, the defendant's response indicates that the people intend to, try to get her exact words here, that we intend to admit in full the personal protection order file that was provided to her subject to the Michigan court rules pertaining to discovery as well as Brady v. Maryland. And that's simply not true, Your Honor. When the people verified that there was indeed a valid personal protection order signed as an ex parte order by this court, the people sought out a copy of the court file so that we could provide that to counsel for the defendant. In the court file were a couple of pages of medical records that the petitioner had attached to her petition for the PPO as evidence that a full hearing was not necessary. The court, having reviewed that entire file, made a ruling on the PPO and instituted the PPO in a separate filing before this court. Now, it seems to the people from the responsive pleadings here of the defendant that that somehow brings all of that petitioner's medical records into play because she attached a couple of pages of medical records to her petition. It is not the people's intent to admit into evidence the entirety of the PPO file. Rather, Your Honor, the only thing we have to show in an aggravated stalking case is whether a valid PPO was in effect at the time of the alleged crime. We don't have to submit the entire court file. We did that as a form of transparency and to comply with the discovery rules. And if that contained a couple of pages of medical records, so be it. But that does not grant the defendant the authority to go on a fishing expedition for the rest of the petitioner's protected health information. Your Honor, what this boils down to is a matter of collateral estoppel. And in order for the proponent, that being the people, to show collateral estoppel, there are three factors that the court must consider. Was a question of fact essential to the judgment was actually litigated and determined by a final and valid judgment? And the answer is yes. There was a PPO hearing, but actually the court granted the PPO ex parte. It was served personally on the defendant, and he had the opportunity at that time to object to the PPO if he so chose. He did not. Subsection 2, the same parties had a full and fair opportunity to litigate the issue. They did. The petitioner filed her application for a PPO with supporting documentation, and this court granted it ex parte. The defendant never sought out a hearing to allow the court to hear his side of the story or to contest the PPO in any way. And subsection 3, Your Honor, there was mutuality of estoppel. And estoppel is mutual if the party asserting estoppel would have been bound by the earlier adjudication if it had gone against them. That meaning if the court had denied the PPO on behalf of the petitioner, would she be bound by the court's ruling? And the answer is yes, of course she would. And the people are citing People v. Trachtenberg, 493, Mitch 38, a 2012 case, and Monat versus State Farm Insurance Company, 469, Mitch 679, a 2004 case as to collateral estoppel. Your Honor, the issue was already litigated and decided by the court. To come back and attempt to relitigate whether the PPO was valid at the time is stopped. It cannot be done because the court already made a decision based upon the facts that were before it. And therefore, Your Honor, we're asking the court to quash these subpoenas because they are, for one, an invasion of privacy as it pertains to Shanna LaViolette. Her private and personal health information is not of any consequence to this case because on the time of the alleged home invasion, she never reported any injuries. She didn't seek medical treatment at that time. If she had, we wouldn't be standing here. But the fact is, the defendant's attempting to relitigate a PPO that was already decided by the court. And therefore, we're asking for this motion to quash. In the alternative, Your Honor, if the court believes that there could be relevant information within those medical records, we're seeking to quash these subpoenas and have them reissued by the court, with the court being the receiver of the documents so that they may be reviewed in camera. And then the court can make a decision as to the relevance or irrelevance of the information contained in those personal medical records. Does the court have any questions of me?
I don't.
Thank you, Your Honor.
Ms. Roberts, your response, please.
Yes, I find Mr. Pahani's argument interesting for sure. There is nothing to indicate in our response to this court, nor anything else to indicate that we are trying to relitigate the PPO. That's not it at all. And as far as all medical records, I was very specific in my request in the subpoena to only include the medical records from January of 24 until I think the end of April of 24, and I don't have that in front of me, unfortunately. Our request is surely not unreasonable and excessive. It's not excessive at all. I'm not asking for her entire medical record. I'm not interested in anything before January. Ms. LaViolette, in filing her PPO, and let me step back a minute. It's my understanding that there was not an actual hearing for the PPO, that it was ordered without a hearing, is my understanding. So she did bring into focus the fact that she had received injuries, but in the information that she provided in the PPO, she did not include any dates or any part of the medical records that would indicate that somehow Mr. Talisman had, in fact, inflicted those injuries. But what's more important and more telling is that this is the defense's opportunity to present a defense, and that's guaranteed. It's clearly guaranteed by the 14th Amendment and the 6th Amendment. Mr. Talisman is entitled to confront and to challenge anything that the witness has already said, or has, and she did put down in her PPO that these were in fact the injuries that were caused. The witness's prior statements are important as discovery as they may be used for impeachment. And that's People versus Dihabanda at 265 Mish 486 is a 1933 case. And it even goes back as far as People versus Davis, which is an 1884 case. This is part of our challenge to the charges. And based on my response to this, to Mr. Pahani's motion, I rely on the response that I filed, and there's nothing to even suggest that this is a fishing expedition. So I ask that the court deny the request of Mr. Pahani and allow us to get those medical records. And not that his alternative would be to have the court look at it. Out of all due respect, Your Honor, I am sure you've gone over many medical records, but there are certain things that I am looking for in those medical records that Your Honor may not be aware of. And as you're not part of our defense team, it would not be something I believe that Your Honor would be able to do. Based on all those things, especially on the motion, the response that I filed, I'm asking again that this court deny Mr. Pahani's request.
Rebuttal, Your Honor.
No, I have a question though. And you have the opportunity though, but
Thank you.
Ms. Roberts, explain the relevance of this. The request that you've made is from January through May 31st. And all of the charging documents that I've read indicate to the court that these charges are alleged to have occurred sometime in July. And I don't have the benefit of the PPO file. It's not in front of me, but I don't even know when that was issued. Can you explain the relevance of it?
Yes, Your Honor. That was issued on April 15th. And in the PPO, she attached 2 sets of medical records. And I have to be careful because I don't want to provide the prosecution with any information about our defense, but it is important. The medical records are important. They could be to the end of April, as far as I'm concerned. I don't need it till the end of May, which would question, and I think this is very important, would question her credibility. In fact, according to People versus Walton, which is a 1976 case, some cases have recognized that discovery is not necessarily limited to evidence admissible at trial, but may extend rather to any information necessary to the preparation of the defense. Also, Your Honor, witnesses' prior statements are important as discovery, and they may be used for impeachment. And I had discussed that one before, but I think that's very important in this case.
All right. Mr. Pahani, your rebuttal argument.
Your Honor, not once in Ms. Davis Roberts' response did I hear the people's prayer for relief that's listed in paragraph 4 in our motion. In order to obtain discovery not provided for by the court rules, the defendant must show that the evidence or information to be discovered is, quote, necessary to the preparation of his defense and in the interest of a fair trial. That's quoting People v. Johnson, 356, Mitch 619, a 1959 case. There's been no offer of proof other than to say, well, I don't want to tell what's going on. I don't really want to explain, but I really need this stuff, Your Honor. That seems to be the argument of the defendant. And to further exemplify that this is a fishing expedition, now counsel has just changed the dates on the subpoena. Well, I don't need them through the end of May, maybe just through the end of April. Your Honor, she has no idea what she's looking for. And the discovery process is not here for a fishing expedition. The issue of the PPO was litigated. She's collaterally estopped from relitigating any issues within the PPO, and the people's exhibit at trial will simply be the personal protection order in and of itself, no supporting documents. But, Your Honor, if these purported misstatements of fact by Ms. LaViolette are allowed into evidence in the trial, then, Your Honor, so too can any other witnesses that might have knowledge of Mr. Talisman's violent behavior toward Ms. LaViolette on behalf of the people. If she's going to try and bring into question the credibility of Ms. LaViolette, then the people should certainly be allowed to counter that with all of the other people that know what Mr. Talisman purportedly did. That would be a broad and wide-ranging trial that is unnecessary for the charge of aggravated stalking. It is the only issue here that involves this PPO whatsoever. Your Honor, we respectfully ask the court to quash these subpoenas.
Your Honor, if I may respond briefly. I find it incredulous that Mr. Pahani continues to talk about relitigation of the PPO, and that's not what we're doing. And is it relevant? Of course it's relevant. It's very important to the defense of this case because she states one thing in her PPO, and yet in the medical records, which I suspect will show something entirely different, it definitely goes to her credibility and the jury's ability to decide, is she telling the truth or is she not telling the truth? That's pretty clear. So for Mr. Pahani to say that I haven't explained that, I think is his misstatement and misunderstanding of my response. Again, I ask that the subpoenas, the motion to quash be denied.
Mr. Pahani, final argument.
Incredulous is probably the nicest thing somebody will call me today. I'll leave it at that.
All right. This is a motion to quash subpoenas that were issued by the defense in this case. And the courts had the opportunity to hear the arguments of counsel. The court looked up the elements of stalking, and there has to be some sort of, how would I describe, emotional type of 17.25. Let me make sure I have this correct. Cause the complainant to suffer emotional distress. I want to make sure I have the buzzwords here correct. And it sounds like it's more potentially looking for a prior inconsistent statement. I'm not getting a firm feel from defense because in part their theory is, well, we don't want to tip our hands to the prosecution, but and I understand that in some respects, but I've done both. I've prosecuted and I've defended. I've actually defended more than I've prosecuted him. And these quote unquote fishing expeditions, I found understandable when when I was either practicing as a prosecutor or a defense attorney. Is it basically where there's smoke, there's fire, but I don't know that. And to hear counsel say, well, it's really something that the court really can't look at, I don't accept that, because I've been under both scenarios. And so frankly speaking, at this point in time, it doesn't appear right offhand that this is essential, but I'm going to order an in-camera of the documents. The court will review the documents. They will be submitted to the court only. The court will review them, and then we'll issue an opinion based upon that.
In that case, Your Honor, the people would ask for the current subpoenas to be quashed because those order the recipients to supply those records directly to counsel. We'd ask for them to be reissued where the recipients must supply those records directly to the court.
Ms. Roberts, can you do that, please?
I'm sorry, you want me to reissue the subpoenas?
Yes, reissue the subpoenas, but to have them sent to the court, the results.
And Your Honor, I'm kind of flabbergasted here that they're going to the court, although I understand in part.
Why are you flabbergasted?
Well, because I think this is a clear case of our right to present a defense. And
It may be, Ms. Roberts, but you've primarily hit on the possibility of prior inconsistent statements, credibility. Credibility is always an issue in any proceeding. And I'm looking for something else. We're talking about private medical records. So by assuring that the privacy maintains by the court reviewing them, if there's something there, you're going to receive it. I've made my ruling on the issue, but can you prepare the subpoenas that the information be sent to the court directly?
Yes, as far as the cost, though, I mean, we're having to pay the cost of them.
It was your request. It was not the court's request initially.
And yet I don't have them, unfortunately. I will prepare them.
All right, thank you. The original subpoenas will be quashed. The new subpoenas will be served accordingly, and the information be provided to the court directly.
If you're enjoying the courtroom chaos here on Gavel Nation Verdict, make sure to smash that like button and subscribe for more unbelievable legal drama, shocking judge reactions, and wild courtroom moments. New cases are uploaded all the time, and trust me, the next hearing gets even crazier.